Judge, at this time, we are prepared to go forward for the entry of a plea. Mr. Daybell, on behalf of Mr. Daybell, we will enter a plea of not guilty to all of the charges and obviously request a pretrial and a jury trial, Your Honor. Thank you.
Okay, thanks. Mr. Pryor, the not guilty pleas will be entered as to counts 1, 2, 3, and 4 in the information.
And welcome to Law&Crime Now, everybody. I'm Jesse Weber. That's where we're starting with Chad Daybell, the man who's been charged with 4 felonies in connection with the discovery of the bodies of his wife's children in his backyard. Now he is seeking to have those charges thrown out. In fact, his attorney, John Pryor, has called the allegations unconstitutional. I'm joined right now by juvenile judge and trial attorney Judge Ashley Wilcott and Law&Crime legal analyst Gene Rossi. Thanks both of you to being on tonight because we have a lot to break down. Gene, I want to start with you. What exactly is John Pryor's argument here? And I know it's a relatively short document, but walk us through. What is he arguing?
Well, he's arguing that there's a constitutionally vague statute, from what I understand, concerning the charges. And the thing about these pretrial motions regarding dismissal of an indictment, whether it's on statutory grounds, constitutional grounds, vagueness, overbreadth, double jeopardy, multiple counts, they are very weak motions. I have a case in Virginia. We're making pretrial motions trying to get a series of indictments dismissed. It's almost impossible to get those granted.
So, Judge, let me turn your attention to one of the lines in this motion. It says, the prosecution has yet to present evidence to support when the alleged acts is supposedly to have taken place and if the defendant acted in any manner to support those allegations. I'm curious, does the defense have a point here? Because in this case, a lot of us are playing the guessing game. There's so many details we don't know. There's so many specifics that we don't know. In fact, we can't forget that neither Chad Daybell nor Laurie Vale Daybell, his wife, have been charged with murder in connection with the kid's death. So is there a point here to what the defense is saying that a prosecution, you just haven't alleged enough?
Well, so listen, it's interesting. In Idaho, the Constitution's a little more narrowly drafted than the Sixth Amendment due process that we're familiar with and most accustomed to. And in it, it's my understanding, and there's some case law, that you do have to say when it occurred. And I think what the prosecution's done is the best they've been able to do based on circumstantial evidence is to say, here was a text from Chad that said he was burying a raccoon in the exact same place that one of the bodies was found. And so there's probably an inference that it happened sometime between that text of when he said he was doing that and when the bodies were found. Does it specifically say exactly when in the charges? No, but they don't have that information. It's the best they can do. I agree with Gene. I think it's not a great argument, but I absolutely believe defense attorneys doing the right thing in raising the argument.
On top of the fact that they say that he lied to police, especially about his relationship with Laurie Vale. So there's a lot for the prosecution here. But Gene, let me ask you this. Pryor has also filed a motion to extend the time for when they'll have a hearing on this motion to dismiss, because apparently he's asked for the transcripts from the preliminary hearing, which we covered here on Law&Crime. What is he looking for in those transcripts?
Transcripts are gold. He's looking for inconsistencies. He's looking for omissions. He's looking for any fatal flaw in the government's case. I can tell you this. Whenever I can get a hold of a transcript of a witness, I always have good things come out of it. When it's my witness, I worry that the other side's going to get the transcript. But I want to go to what the judge just said. If you can't charge a specific time frame, the case law in Virginia and almost every state, including Iowa, gives a lot of flexibility on in or about, around about. You know, the time frame for a crime is very fluid. So even though that text talks about a raccoon and they're trying to develop the time by circumstantial, that may be enough to get over the low bar that a prosecutor has to go over to establish the time of a crime.
Well, I'll tell you what, let's go back to the preliminary hearing when we heard from prosecutor Rob Wood in his closing argument try to summarize what the allegations against Chad Daybell are. Here's a portion of it.
I'm aware this court is very well aware of what the burden of proof is for a preliminary hearing due to the wide audience it reaches. I'd just point out that Idaho criminal rule states that if the court finds that an offense has been committed and that there is probable or sufficient cause to believe the defendant committed the offense, the court must bind that defendant over to answer in district court. And so, Your Honor, just a brief recap. On November 25th, the Rexburg Police Department was notified of a missing child, J.J. Vale. The next day, their investigation begins. What they discover in the course of that investigation is that there's another missing child, Tylee Ryan, and they discovered that the last day she's seen is September 8th in Yellowstone National Park. They find evidence that on September 9th, Chad Daybell sent a text to his then wife, Tammy Daybell, at 11:53 in the morning about burning limb debris and burying a raccoon in his pet cemetery. That very same morning, Alex Cox's phone pings in that same area, that pet cemetery area on Chad Daybell's property. On June 9th, Tylee Ryan, who we've identified through DNA, is found buried, burnt, dismembered portions of her in a green melted bucket, buried with animals in the pet cemetery. Through that investigation, they find that the last known sighting of J.J. Vale was September 22nd. The last known sighting of J.J. Vale was September 22nd. Similarly, on September 23rd, Alex Cox's phone pings on Chad Daybell's property. Near those pings, where those pings are located on the north side of Chad Daybell's property, on June 9th, JJ is found, wrapped in a garbage bag with another white garbage bag wrapped around his head, bound in duct tape.
Okay, so you hear the prosecution making those allegations, and also it should be noted, Alex Cox is the deceased brother of Laurie Vale, and the government believes that he had quite the role in what happened with the kids. What role, we're still trying to figure out. But you heard the prosecution. Now let's turn to John Pryor, again, the attorney for Chad Daybell, who's filed this motion to dismiss. Here was his argument back in the preliminary hearing.
The testimony, according to this prosecuting attorney, is that Mr. Daybell was married to Miss Vale. That's doesn't provide anything. Not only doesn't it provide an overt act, it doesn't provide an agreement. Marriage is not an overt act towards a conspiracy, and marriage is not an agreement to conceal or to conspire. In addition, what they have is Mr. Daybell making a comment to a police officer. That is not an overt act to conspire or an agreement to conspire as well. And then what they have is they have an obscure text message that says, I burned some items in the fire pit and I buried a raccoon. Now, they can suggest whatever they want with that, but there's been no indication of any evidence that this act took place on the 9th or the 22nd or 23rd or whatever day it was. And quite honestly, Judge, they don't even come close on the concealment of Tylee. They don't even come close on the concealment of JJ. And the conspiracy, they lack the agreement. And quite honestly, Judge, if this is what the evidence is in terms of an overt act, I would submit to the court that I understand the burden in a preliminary hearing, but they aren't even close on the conspiracy in either suggestion, that in either case, in regards to an overt act plus an agreement. I'm respectfully asking the court to dismiss the charges. They haven't met their burden, and I don't believe they have provided any near the type of evidence that is necessary to even overcome that small threshold. Thank you, Your Honor.
Okay, Judge, clearly echoing sort of what he was saying in his motion to dismiss, but let me turn now to Laurie Vale, okay? And you have to wonder, we're dealing with these two separate cases. She's facing almost identical charges to him on the conspiracy counts. Are we expected to see, or are you expecting to see Mark Means her attorney file a motion to dismiss on her behalf now that Chad Daybell's attorney did this. What do you think is going to happen now with her case?
I would think that the attorney would file a similar motion because the same arguments exist. The exact same scenario faces each of these two defendants. And I do want to say also one other point about the marriage piece. Of course, marriage in and of itself does not mean conspiracy. However, how the two married individuals are acting, what they are communicating can amount to a conspiracy. So I think that's the next step, and you have to look at the whole picture.
Gene, let's read the tea leaves if we can. There's a lot of time between now and Chad Daybell's trial in January. What could happen between now and January? What are you looking out for, aside from a hearing on this motion to dismiss? What could happen? What could realistically happen?
Well, here's what happens right before trial, in the months leading up to trial, the weeks leading up to trial. You're going to find that the prosecutors are going to find more evidence, are going to get possible more witnesses. It's amazing as you lead up to a trial how someone comes out of the woodwork that wasn't available before. That's the possibility, number one. Number two, we still got that Arizona thing going on that I don't know if you were going to bring up. They still got troubles down in Arizona, okay, that they're investigating a murder down there. So something could arise from that event regarding the husband of Laurie, and that could delay the trial of Chad Daybell. The third thing that could happen is the judge could rule in their favor. But the last thing I want to say is Judge Wilcott's right. They're probably going to, in Laurie's case, file a sister motion because they probably have a joint defense agreement and are like peas and carrots. They're mirroring each other.
Even though the judge had said that there was to be no contact between Laurie and Chad directly. You know, it's interesting,
but not their
Judge,
attorney.
when we listen to this back and forth, well, that's true, not their attorneys. But Judge, let me ask you this. Do you think that Chad has a weaker, or the prosecution's case against Chad might be weaker than Laurie's? Because let's not forget, Laurie, those were her kids. And although Laurie and Chad seemed to be joined at the hip and he was visiting her every day until he was ultimately arrested, is there a possibility that she could have lied to Chad about what was going on and burying the kids in his backyard? Because they were her kids. And she is known to be accused of lying multiple times in this whole sort of ordeal. What do you think? And
Well,
about 40
absolutely.
seconds.
Yeah, of course it's possible that she lied. But listen, the fact of the matter is they were both involved in some way, because even if she lied to him, it is his property. He should have known what was going on. I'm positive they've had discussions about whatever did and didn't happen. And I think she's going to face the same consequences, or rather he is, as her.
Well, I got to tell you, there's a lot of time between now and that trial. A lot, as Gene said, could happen. We're going to be waiting to see what happens next, including with the investigations into the deaths of Tammy Daybell, Joseph Ryan, Charles Vale. It's also eerie, also strange, and just also heartbreaking. We'll take a break. When we come back, we're going to focus on an update in the Golden State Killer case. We'll be back. Welcome back, everybody. Now, you would think that after Joseph James DeAngelo pled guilty to multiple murders, admitted to dozens of rapes and burglaries, and was sentenced to consecutive life terms in prison, that would be the end of the story for the man who basically publicly identified himself as the Golden State Killer, right? Well, not exactly. There is a group of alleged sexual assault survivors who are now asserting that they may have been victims of the Golden State Killer as well. They've identified themselves as the Missing Cases group, and they're asking for their cases to be reinvestigated. Now, this kind of brings us back to what happened after DeAngelo's sentencing, when we heard from Sacramento County Prosecutor Anne Marie Schubert. Take a listen to what she had to say.
Is the work on this case completed? Because I've spoken to one of the special agents that investigated this in Sacramento, and he said there were still rapes, murders that he believed was linked to Joseph DeAngelo, but hasn't been proven yet.
I mean, I think we'd all probably collectively say, and many of the folks like Erica Hutchcraft from Orange County, Paul, Ken Clark, Larry Poole, who have dedicated their lives, I mean, We know what we know, Rowena. That's where you go. We know what we know. We know, because of the power of the data bank that the Harringtons brought to us, we know what's been put into it, and we know what's been linked. Does that mean that there are not other crimes out there? Absolutely not. I don't believe we will ever know the magnitude of what Mr. D'Angelo did.
Gene, that is a big statement right there. So I'm curious, with this missing cases group, how is this going to play out for them?
Well, I'd have to look at the statute of limitations, and a lot of states have no statute for rape and murder, of course. And my view is this. I know that the prosecutor, Ms. Schubert, feels that we've done enough, and we may just have to move on and live with the fact that Mr. D'Angelo has other victims and crimes out there. But I got to tell you, if I'm a victim, a relative of a victim who passed away, I would want that investigated. And they could open a grand jury investigation. You got to understand, he has immunity. He has immunity when he pleads guilty for the crimes he admits to. He doesn't have immunity for the acts that aren't in his plea agreement. So if he admitted to 13 murders, but there are about 15 others out there that aren't addressed in the plea agreement, he doesn't have immunity from that. So they could investigate, and academically they could charge him, and he probably would plead guilty in a New York minute. But I think those victims have the right to have their cases investigated. You know why? This is the most horrendous, most vicious, most vile murderer and rapist in the history of the United States and the world. And if any case deserves more investigation than what they've already done, this one deserves it.
Gene, I think you're 100% right. I mean, survivor Susan Bolus told a local media outlet, she goes, for all these years, for me, 1979, that's 41 years of not knowing who it was. And you'll never have complete closure because you carry the emotions of whatever happened to you. And in this case, rape. But there could be some kind of a closure of at least knowing who it was. Ashley, what do you think about that? I want to give you a turn to your thoughts on this.
I think there are two different pieces of the puzzle. One is investigating to find out if evidence links him to the person who committed these crimes on these other unsolved cases. Absolutely, that needs to happen. All the reasons Gene said for these victims. But Jesse, keep in mind, when he entered this plea, the way he got the death penalty off the table was he did plead to any uncharged crime. So number one, that leaves the door wide open, I think, for these other victims to say, we want our cases investigated to see whether or not he is the person that did this to me. And number two, it does mean I don't think he'll be prosecuted for it, but I don't think that's the point at this point in the process.
Well, look, the question is, will he say anything? Will he help prosecutors? Will he help these women provide closure? I mean, we heard from Joseph James D'Angelo himself during his sentencing. Remember when he said this?
I've listened to all your statements, each one of them. And I'm truly sorry to everyone I've heard. Thank you, Your Honor.
And that was very nice of him. Very nice. Okay, so we turned from one horrible person to the next. Let's finish up with Harvey Weinstein. Even though he's currently serving a 23-year prison term for his sex crimes convictions here in New York, there's still a legal battle for him in the civil side. We can't forget that we reported to you here on Law&Crime Now that there was an earlier settlement between Weinstein, the former officers and directors of the Weinstein Company, and Weinstein's alleged victims that was tossed out by a federal judge for multiple reasons. Well, now a new plan is being put forth, and this proposed plan has really different terms. First, the planned payout to the survivors was decreased by $7.2 million. It also excludes those who were victimized when Weinstein operated Miramax. Now, on the other side, this new plan, unlike the previous one, Weinstein's legal costs are not going to be covered. So that's just a few of the different things that we're looking at here. You know, Gene, I want to turn to you. What do you make of this proposed new deal, including the fact that it doesn't have to be approved by Judge Hellerstein, who rejected the earlier plan. They can actually get it approved by a different bankruptcy court judge. What do you make of this new deal?
Well, I did federal bankruptcy cases for the U.S. Department of Justice. And here's the problem, the bad news for victims. When you're in bankruptcy, the pie is just very limited. And you got all these creditors trying to get involved in everything. So sometimes for the victims, even though they feel they deserve a maximum amount of compensation or indemnity, if you will, sometimes these deals you have to give a little bit because it is bankruptcy. It's a different animal. It's not a civil case. You can't squeeze water out of a stone.
So that kind of brings me to my next point. And Judge, I want to turn to you. We have attorneys on different sides, attorneys Douglas Wigdor and Kevin Mincer, who represent the plaintiffs that have chose not to go into this settlement. They've called this new plan more offensive than the version that was rejected previously. They argue that most of the money is not going to go to the survivors, and they want a liquidation of the Weinstein Company estate. But on the other hand, you have Beth Fegan, who actually represents the plaintiffs that want to settle. And she said, I find it troubling that a small number of detractors are attempting to derail a settlement that would help a larger group of survivors who are interested in resolution now rather than years of additional trauma. Who's right?
Well, I don't think either one is necessarily right. The fact of the matter is attorneys have clients and they represent the position of the clients after giving them an advice. In this case, you've got individuals who are survivors of horrific crimes who, guess what? They have different opinions as to how to proceed and what they want to do. These are the legalities of the system in which we operate in civil cases and in bankruptcy. And so I don't think either one is right. They both have the opportunity to pursue it the way they're pursuing it. They just have to be really cautious that in doing it one way, they don't completely wipe out all of the rights of the other victims.
Yeah, one of the arguments was, because they fought so much against the other settlement, some people were opted out of this new one. And there's no easy answer. It's an individual decision, and obviously Judge Hellerstein's decision will be appealed as well. Gene, Judge, thank you both for coming on. Everyone out there, thanks for joining us here on Law&Crime Now. Until next time, stay safe.